Hi everybody, John here. I have some mediation preparation tips for you that I wanted to share with you for your upcoming mediation. These are some things that I've put together that are common questions that people ask, and I want to give you the best knowledge that I can give you prior to this mediation. One of the first questions is, why do we even have mediations? Can't we just settle this case? Yes, we can. But as litigation and the courts have evolved through alternative dispute resolution processes, mediation has become more and more popular in the last 15 years or so. One of the main advantages to mediation is it is a great opportunity to settle your case. Why is that? It is a day, usually a half day, sometimes a full day, sometimes 2 days in more complex cases, set aside for all of the lawyers and for all the parties to do nothing but focus on your case. No phone calls, no distractions. Everything is set aside for you. We want to put 100% effort in focusing on getting the best value and the best outcome for you in your case. Another reason that we mediate cases is the court rules, what we often refer to as the local rules, require it. A lot of the judges don't want to put cases on their calendar or trial dates on their calendar without the parties going through mediation first. So sometimes, and many times, and most of the times in Tennessee, a mediation is required before you get a trial date. I'll give you my thoughts on that. My thoughts on that are it's not a good rule. It used to be, back when I first started practicing law in 1998, it used to be that we would get a case ready for trial. The trial would be 30 days out, and the mediator, the defense lawyer would call me, the insurance lawyer would call me and say, "Hey, John, can we mediate this case before trial?" Sure. And you could get a quick mediation date. There weren't a lot of mediations going on. There weren't a lot of mediators. And we would go to a mediation, and both sides were, what I say, at the foot of the cross. There's a day of judgment coming. The problem, in my opinion, with mediating a case now is that we have to do it to get a trial date. There's still a lot of time, so there's not that immediacy that we've got to do something now. A lot of adjusters will evaluate the case, and if it doesn't settle, it doesn't settle. And you still got more time, and you can still settle at any time. I can promise you that we are going to know everything there is to know about your case, and we're going to do our very best to get your case settled at mediation. Of our cases that go to mediation, we settle about 70% of those cases. That number used to be higher, but that's about the average number of cases we settle. And of the 30% that we don't settle, we still settle about 100% of those prior to trial. So know that going into this mediation, we are going to focus strongly on your case, but even if we don't settle your case, there is still a great probability that we are going to settle your case before trial. Who is the mediator? A mediator is typically a lawyer who's been practicing for several number of years, and they've got some experience under their belt, usually in the same area. Hopefully they better be in the same area of the practice for which they're mediating these cases. Typically they're certified by the rules in Tennessee and the Supreme Court rules. They are certified as mediators, and they start mediating. They charge hourly for their services, and their goal generally is to get the case settled or to find some resolution in the case. Many times I will personally pick the mediator for your specific case. Sometimes there's a better match in personality. Sometimes we have male issues, we have female issues, and I want to get a male or a female mediator based on those things. But most of the time, there's an available pool of mediators. Many of them are very good, and if we've chosen them, there's a reason that we've chosen that specific mediator for your case. What are the advantages to mediation? One of the advantages of mediation is it helps avoid stress to you by getting your case resolved. Litigation is stressful. Having your deposition taken, if you remember what that was like, was pretty stressful. And if you think that's stressful, going to trial requires a lot of preparation, Now, I spend a lot of time with you getting you ready for trial because it's very important. If we settle your case ends and you avoid that stress. A lot of people, especially ones with higher anxiety, sometimes don't do as well in trials. And that's one of my biggest concerns in preparations in trials. So I want to get you ready, but in the basket of advantages, settling your case ends your stress. And so a lot of people find that very helpful. A second advantage of mediation is you avoid uncertainty. I would love it if I had 12 of your closest and best friends in the jury box when we try your case. Unfortunately, you get people that don't give a rip about your case. They're looking at their watch. They got children to pick up. They don't want to be there. And you don't get the same kind of point of view that they don't know what you've been through. They don't have the emotional connection to your case that you do. It's my job to help facilitate a connection with you to your case if we go to trial, but they don't have that, at least right now. So we don't know what type of verdict you're going to get. The verdicts can be all over the map. We've got a great track record, and I'm proud of that, but I'm not Jesus, and I can't tell you exactly what's going to happen in your case. A lot of things can go into what happens, the judge that we get, the jury that we get, how testimony goes, how experts perform. There's a lot of unknowns in these cases. So settling your case avoids uncertainty. Number three, the third advantage is you avoid future expenses in your case. If we haven't done all of our trial prep at this point, or there are other experts or doctors' depositions we've got to take, those are expensive. And those are costs that you don't have to incur. There's also the time value. Your case settles earlier rather than later. You don't have to wait 6 months, a year and a half to get your money. It's done. Your case is resolved. The stress ends now. And when you're evaluating a case, you've got to think realistically and see the big picture. Yes, sometimes it's worth it to settle now for slightly or a little bit less money than you get at trial, because it's going to cost you more if you go to trial. So what I'm concerned about and what you're concerned about at the end of the day is, what is your net result going to be? So you have to take all these things into factors as consideration whenever you're going to mediate your case. Another advantage for me as your attorney and any of our lawyers that work at Griffith Law is I get to spend a lot of time with you. We've already spent time with you getting ready for your deposition and all the things that led up to that, doing all the discovery that we did. But I love my clients. I love you. I want to sit beside you and I want to get to know more about you. And as a lawyer, that helps me get prepared in case we don't go to trial. And every time I've gone to trial, I have passionately fought for my people because I care about them. I love them. I know the hell on earth that a lot of them have been through, and a lot of the problems they had, and a lot of the uncertainty, and just the desperation that they've had. So it helps me to get ready. And also, we use this time. There's a lot of gaps of time where we're just sitting around waiting on the other side to move at a mediation. And we use that to plan the future of your case in the event that we don't settle the case. I do that every mediation. Even every one that I settle, I'm sitting there planning what we're going to do if we don't settle the case. And I'm telling you that, and I need your participation in that, and I want to educate you on what I think the next steps are. Yet another advantage of mediation is you get confidentiality of your settlement. So if you settle your case, your Uncle Earl doesn't know how much money you got, and it's none of his business. If you go to trial and get a verdict, every verdict is public record. Anybody in the world can see it. If you do great, they're going to see it. If you do poorly, they're going to see it. It can be picked up by reporters. Other defense lawyers rely on these things and on these judgments. I rely upon them as well. But it's public. Many cases that settle out of court are confidential. So yet another advantage to mediation. If your case doesn't settle, another advantage to mediation for me as your lawyer is we get to explore the defenses that will be used against you. Many times at a mediation, in order to inject uncertainty and to try to lower the value of your case, the defense will leak some of the things they're going to use against you in your case if your case goes forward. There are many examples of this. Sometimes they will say, oh, here's a record from 12 or 14 years ago where she had neck pain, if it's a neck injury case, and try to say, well, she didn't tell this to her doctor. And maybe the client forgot about it or whatever, but then they'll say, oh, well, gosh, she wasn't honest with her doctor, or things of that nature. And so it helps me, and I'm soaking these up like a sponge, because we're all offense, but sometimes we got to play defense too, and I need to know these things. So I'm very aware of what they are saying. We're taking note of that, and we're going to use that to prepare your case if we don't get it settled, so we can move forward and move forward stronger for you. All of these things are advantages to mediation. Now let's talk about some disadvantages. There are ways that you can have disadvantage to mediating your case, particularly when it's done too early. The problem with that is when you don't have enough information about the defendant, about the other side, to use that information against them. For example, in a trucking case, many trucking cases that we have, there will be logbook violations, there'll be above hours of service violations, and you haven't had a chance to fully discover the case because the insurance company and lawyer for the defense has said, hey, this liability is clear, we're clearly at fault, let's go ahead and mediate this case and get it over with early. There might be some training issues, some system failures by that corporate defendant, multiple wrecks in the past, safety rules not being taught properly at that company that lead it to a continuing and ongoing danger. And those are things that if we knew about it at the time of mediation, it would significantly increase the value of your case. So when I have a good case and I have a corporate defendant asking me, John, hey, they're being all nice and they call out and instead of being mean, they'll say, hey, can we mediate this case? And I'm like, man, I'm just not ready yet. I need to dig deeper. And about every time they've asked for an early mediation, I've been right every single time, and we found some really powerful harms to the defendant that have significantly driven up the verdicts or the outcome of the case, the reason that they want to get rid of that case, the reason they were calling us in the first place to try to get their cases resolved early before we had a chance to delve and force them to give information to us. A second reason is to avoid uncertainty on the strength of your case. If you have a neck injury, for example, this is very common in car wreck cases, but you had a prior injury that was resolved for a number of years and you had no problems, and then you're involved in this big wreck and now you've got a neck surgery. The defense wants to go to mediation early in those cases, sometimes when fault is clear, because they want to inject uncertainty into your case. And when you do that, uncertainty lowers the value of your case. Uncertainty is the killer to a great outcome in your case, and we've got to avoid that. And how do you avoid that? Well, you spend the time and effort as a lawyer and you take the doctor's deposition of your client. And you get that doctor to say, most likely, this is what happened. I knew about this prior injury. I knew that was an issue, or they've got degenerative disc disease. But you know what? It wasn't causing them pain at the time of this wreck, not immediately before the wreck, and this is what caused it. When you're armed with that, as simple as that sounds, when you go into a mediation, it takes away a lot of uncertainty. Now, in fairness, they may have their own doctor, who's usually a hack, who's works for insurance companies all the time and makes a great living just doing fake opinions for insurance companies. They're going to have their own little doctor to say this too sometimes. But if we go ahead and depose your treating doctor, it goes a long way in avoiding that uncertainty. So sometimes I'll want to go ahead and depose that doctor first before we go to mediation. That takes some time. We've got to coordinate everybody's schedule. It just takes time and it takes work. And some lawyers don't want to work. I'm not bad-mouthing lawyers, but some don't want to take that time and effort. So when I've got a clear causation case, pretty clear, or when it's reasonably clear, then I want to go ahead and proceed and take that deposition first to avoid all that chatter we're going to get from the other side at a mediation. In a commercial case, another disadvantage to going to mediation is we haven't had a chance to take the corporate representative's deposition. This is a key and it's a requirement in all of our cases before we go to mediation at GriffithLaw. All of our lawyers are trained and required to take the deposition of the person who speaks for the corporation if there's a corporation involved in your case. And the reasons for this are multiple. One of the reasons is most of the time they're not prepared and they really don't care. They don't give a rip about your case, or they don't give a rip about the safety violations that they've entertained. And what we do is we use this as leverage and power to beat them up at these mediations, or try to if we have good facts, and increase the value of your case. They know how that is going to play in front of a jury if you've got a corporation that's had numerous safety violations and they refuse to do anything about it to make their premises or their vehicles or their drivers more safe. Let's talk about what you will not see at a mediation. In Tennessee, you will not see a confrontation. You will not see you sitting on one side and the defendants sitting on the other. And I think that's a good rule or a good practice. It can be done. But if you start out a mediation where you're trying to bring both sides together to reach a resolution, if you start off with pointing the finger at the other side and then pointing the finger at you, it causes your defenses to go up. And that's not going to help anybody settle your case. So that you're not going to have a confrontation with the other side. You're going to be in a room with me or GriffithLaw lawyers, and the mediator is going to come into a conference room. It's just going to be us together. The defense will not be there, the insurance lawyer will not be there, the insurance adjuster will not be there, and the defendant, the person that's caused you all these harms, will not be there most of the time. They certainly won't be in the room, they may not be even in the building. So don't worry about that you're going to have to give a statement or anything that you say is going to be on record. It's all confidential. This is a day of complete peace to you, confidentially wise. One of the rules of mediation is that all offers to settle your case are not admissible, ever. They cannot be used against you. And same for the defense. Their offers and whatever they offer can't be used against you. If it goes to trial, a judge will not know, and the jury will certainly never know what you offered to settle for. So if your case is worth, I'm just making up numbers, $100,000, but you came down to $50,000 trying to settle your case to get it over with, or 80 or whatever, judge never knows it, jury never knows it. And you're not precluded from asking for $1 million, or a jury giving you $1 million, or whatever the value of your case is at trial. So you're not capped by what you ask for. That if the rule is designed to promote offers and to compromise cases, and if you thought, or if the rule was, oh, this can be used against me later, then it would not entice people to get together and try to reach common ground. So don't worry about it. This is a free day. Any negotiations, not just on mediation day, but all negotiations are confidential, always. Second thing you will not see is an apology. 99.73% of the time, you won't see that. I have had 1 or 2 mediations in my career where the defendant showed up. It's a very stressful situation, very huge losses, and I think maybe twice in my career, the defendant was there and the defendant apologized at the end of it. Just know that going in. This is a chance for the insurance company to get this case off their books and get this claim resolved. Does mediation cost me money? Mediators charge by the hour. Their goal is to get the case resolved. If they can, it's great. It's a binding agreement on both parties. In most cases, if your case settles, in the approximately 70% of the time your case settles, the defense, as part of settlement, the insurance company will pay the mediation costs. That used to be kind of the norm, but now less and less companies are doing it, so we have to factor that in. Sometimes we've walked away from mediation on who would pay the mediation costs because we could barely reach a settlement, and that was kind of the straw that broke the camel's back. But I would say in a majority of the times, the insurance company will pay that. If not, it's usually about $1,000-ish per side on that. And that, if we don't settle your case, that goes into the expenses of your case and comes out at the end of the case as part of your expenses from any verdict or subsequent settlement that we have. Let's talk about some common misconceptions at mediation. We've touched on a couple of them already. The defendant may not be there. If mediation is not required, I demand that the defendants be there as part of it. Sometimes if companies do want to mediate early and we've got maybe some issues with our case that could be potential problems in our case, there could be big problems, we will require the defendants to be there. We try to require adjusters to be there, just so they can have skin in the game. Also, when the defendant is there, they can put pressure on the insurance company because they've been sued, they want to get this case resolved. Insurance companies don't always look at it from their point of view. Another common misconception at mediation is, well, we're being weak because we're moving a lot more than they are. This mediation is a negotiation process. We start high, they start low. Their first offer is going to probably get you angry. I'll prepare you for that, but it's going to get you upset. And on the flip side, our demand is probably going to make them upset. I don't get emotional about these mediations. This is not divorce court, as I always say. But we're going to start high, they're going to start low. And we may start higher than the midpoint of the range of your case. So if we move down 10,000, they come up 5, don't get hung up on that. You'll forget this as we go along and negotiating your case, I promise you, because everybody says this. This always happens. But John, we're moving so much more than they are. That is the way these things typically go. You have final say. If you don't want to accept a number, I will always give you my advice and my opinion and the chances that we can go do better at trial, significantly better. But you are the boss. You hold the keys to the day. I cannot force you and would not want to force you to do anything. I want this to be your decision. Another misconception is, well, my bills were this, and this is not as much above my bills as I'd hoped for. I want you to know at the outset that the bills, particularly if you have health insurance, they are negotiable. We'll go into the intricacies of your specific set of facts, but you need to look at it from the numbers that we're able to obtain and share that with you during the negotiations in your case. Another misconception is that the adjusters are evaluating this as they go along. They can be pushed in their evaluation of your case. A good mediator will push both sides, in fairness, but the adjusters usually have already roundtabled your case with a group of managers or legal department people at their insurance company, and they've already got an evaluation of your case. So, and they're just going to slow walk you to that point. So sometimes, I try to keep my people well fed and rested because sometimes it's an endurance contest. And I don't want you making decisions just because you need to get out of there or go pick up your kids or you're hungry. And I want to make this process work for you. So these are some common things that I want you to think about as you go along. Another misconception is that we have to get your case settled today. We can walk away. Sometimes we have 2 mediations in cases. I've got several cases where we had an early mediation and then we weren't even close, and then we take a bunch of depositions, multiple doctors' depositions, and the defense says, hey, John, we've got more information now. We'd like to be more fair and try to get this thing resolved again. It's not a requirement, so I'll say, yeah, if you pay for it, and my client agrees, and you want to settle the case, and you're going to bring the right money this time, then yes, we'll do that. So don't think that you've got to get your case settled, and don't think that if you don't settle your case at mediation, your case is definitely going to trial. That is not true. As I said earlier, still 99% of cases settle even after mediation has failed. So it is a great opportunity to get your case settled. It's where a lot of effort is going to be put into getting your case done, but it's not a requirement that you have to get it settled that day or you can't settle it the next day. I've settled them the next day, I've settled them the next month, I've settled them while I was picking a jury. Another common misconception that my clients have had in the past is that the mediator himself or herself has any judge-like authority. Mediators have no decision-making authority. They can give you their opinion if we ask them to do that, but they can't force anybody on either side to do anything to get your case resolved. But that's the purpose of a mediator, is giving both sides a reason to settle. And a good mediator will work on both sides and push both sides to get them settled. I will tell you, and I'll tell many people, that the mediator's job is to get you down and to get the defense up. And if we can meet somewhere and have those two sides touch, then we have your case settled. And that's the goal. I hope this video has been helpful for you in getting prepared for your mediation. I hope it gives you some peace of mind as we go through this process. It is a process. It's a process that we do weekly here. This is your only one though. And if you've got any questions that we haven't answered through this video, we're going to be spending a lot of time together at this mediation, probably at least 4 hours usually at a minimum. I want you to ask any questions that you have, and I want you to fully understand the process. So as we go forward, I'd ask that you be a little flexible, trust the process, but I want you to have full knowledge, and I want all your questions to be answered. So we're looking forward to this. We hope to get your case resolved. If we don't, it's not the end of the world. We're still going to move forward, and we're going to give them every reason to get your case resolved prior to trial. If not, we're going to do the very, very best to let a jury evaluate your true harms and losses. The insurance adjusters don't always get the last word. I always preach that to my people. The jury will evaluate this based on common sense and human harms. So good luck, and we thank you for letting us work for you. Thank you.